All rise. We vous levez. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. We was a swap.
Good afternoon to everybody. Would the court officer please call the case?
Thank you, Mr. President. The situation in the Central African Republic in the case of the prosecutor versus Jean-Pierre Bemba Gombo, Eme Kilolo Musemba, Jean-Jacques Magenda Kabongo, Fidel Babala Wandu, and Narcissa Rido. Case reference ICC 0105-0113. For the record, we are in open session.
Thank you. My name is Howard Morrison and I am the presiding judge in this appeal of Mr. Jean-Pierre Bemba Gombo against the decision of Trial Chamber 7 of the 17th of September of 2018 entitled Decision Resentencing Mr. Jean-Pierre Bemba Gombo, Mr. Eme Kilolo Musamba and Mr. Jean-Jacques Magenda Kabongo. In today's summary, I will refer to this decision as the resentencing decision. Now may I ask the parties to introduce themselves for the record, beginning with the defence.
Good afternoon, Mr. President. It's Melinda Taylor appearing on behalf of Mr. Jean-Pierre Bemba, and I'm assisted by Mr. Mohammed Youssef. Thank you.
Thank you. And for the Office of the Prosecutor?
Good afternoon, Your Honor. The prosecution is represented today by Mr. Kwaeku van der Pue, Senior Trial Lawyer, Mrs. Niveda Thiru, Assistant Appeals Counsel, and myself, Mary Che Rege, Appeals Counsel. Ms. Brady and Ms. Narayanan were unable to attend and they send their apologies.
Thank you. Now today the Appeals Chamber is delivering its judgment on the appeal of Mr. Bemba. In a moment I shall summarise the Appeals Chamber's judgment, which was taken unanimously. This summary is not part of the written judgment, which is the only authoritative account of the Appeals Chamber's ruling and reasons. The written judgment will be made available to the parties and participants at the conclusion of this hearing. By way of background, following appeals against an initial guilty verdict for offences against the administration of justice pursuant to Article 70 of the statute, the Appeals Chamber confirmed two of Mr. Jean-Pierre Bemba Gombo's convictions in 2018, namely the convictions for having corruptly influenced 14 defence witnesses and for having solicited the giving of false evidence by these witnesses under Article 71A and C of the statute, respectively. The Appeals Chamber overturned Mr. Bemba's conviction for having presented evidence that a party knows to be false or forged under Article 71B of the statute. Mr. Bemba was sentenced to 1 year's imprisonment and a fine of €300,000. Upon the prosecutor's successful appeal against the suspended sentences and other sentencing matters, the Appeals Chamber found that the Trial Chamber committed errors with respect to the pronounced sentences. Amongst those errors, the Appeal Chamber found that the Trial Chamber erred, 1, in its assessment of the nature of the false testimony given by witnesses on non-merits issues, and 2, in its justification for distinguishing principal from accessorial liability in this case. Consequently, the Appeals Chamber reversed Mr. Bemba's sentence and remanded the matter to the Trial Chamber for a new determination. On the 8th of June of 2018, in the case of the prosecutor against Jean-Pierre Bemba Gombo concerning crimes against under Article 5 of the statute, referred to as the main case, the Appeals Chamber, by majority, discontinued the proceedings with respect to some of the criminal acts charged and acquitted Mr. Bemba of the remaining charges. Following Mr. Bemba's acquittal, the Trial Chamber ordered on the 12th of June 2018 the conditional release of Mr. Bemba. On the 17th of September of 2018, the Trial Chamber resentenced Mr. Bemba to 1 year's imprisonment and imposed a fine of €300,000 to be paid by Mr. Bemba within 3 months of the resentencing decision. Mr. Bemba appeals the resentencing decision on 3 grounds. As a preliminary matter, I note that Mr. Bemba filed a request for the admission on appeal of additional evidence. For the reasons set out in the judgment, the Appeals Chamber rejects Mr. Bemba's request. I now turn to the appeal. Under his first ground of appeal, Mr. Bemba argues that, in its assessment of the gravity of the offence and the degree of his participation, the trial chamber did not comply with the directions on the determination of the new sentence. The Appeals Chamber rejects Mr. Bemba's arguments for the following reasons. In its initial sentencing decision, the trial chamber distinguished false testimony which witnesses given on the merits of the main case from false testimony on non-merits matters. The trial chamber noted that the issues on which concerned witnesses testifying falsely did not pertain to the merits, and this informed the trial chamber's assessment of the gravity of the offences. The Appeals Chamber recalls that in the Bemba et al. Sentencing appeal judgment, it rejected the trial chamber's abstract distinction between these 2 types of false testimony. Given that the weight afforded to this distinction in the trial chamber's sentencing decision of March 2017 had arguably led to a slight reduction in the sentence initially imposed, excluding this distinction in the resentencing decision naturally led to a slight increase in the sentence. In addition, the Appeals Chamber recalls that, quote, false testimony on issues which go to the credibility of a witness prevents the court from obtaining correct information which may be necessary for an accurate assessment of the reliability of his or her evidence, end quote. The trial chamber took this into account when assessing the gravity of the offences for which Mr. Bemba was convicted and the extent of the damage caused by them. Moreover, contrary to Mr. Bemba's averment, the trial chamber followed directions issued by the Appeals Chamber. The increase of the sentence for the Article 71A offence was a direct consequence of those directions. When assessing Mr. Bemba's culpable conduct, the trial chamber recalled that in the sentencing decision of March 2017, it had considered Mr. Bemba's degree of participation, including his varying degree of participation in the execution of the offences, and referred to the relevant paragraphs of that decision in which the trial chamber set out a detailed factual assessment of Mr. Bemba's degree of participation. It was precisely on the basis of this factual assessment that the Appeals Chamber, when reviewing that decision, found that the relevant factual findings underpinning the convictions entered for Article 71A and C offences were essentially the same. The trial chamber correctly relied on this finding of the Appeals Chamber. Finally, regarding Mr. Bemba's argument based upon an abstract comparison between various modes of liability, the Appeals Chamber notes that the sentences imposed on the persons convicted in this case were fact-specific and based upon their individual circumstances. Therefore, such an abstract comparison does not warrant consideration. Under his second ground of appeal, Mr. Bemba argues that the trial chamber abused its discretion and erred in law and procedure by failing to remedy the cumulative effect of egregious violations of his rights. He first submits that the trial chamber erred in finding that his detention was lawful. The Appeals Chamber rejects Mr. Bemba's contentions for the following reasons. The Appeals Chamber notes that throughout the entire period of his detention in relation to the present case, Mr. Bemba was also detained in relation to the main case. The unavailability or potential ineffectiveness of remedies with respect to his allegedly unlawful or excessively long detention in the present case was a result of his detention in the main case. If seized with an application for interim release in the present case, the trial chamber would not be able to release Mr. Bemba, whether or not the release was warranted. All that the trial chamber was able to do in this case was to credit the time Mr. Bemba spent in detention when determining his sentence, which it did. The Appeals Chamber also rejects Mr. Bemba's contention that his right to be tried without undue delay had been violated, as this argument is raised on appeal for the first time, and in any event there appears to have been no unreasonable period of activity on the part of the pre-trial chamber 2 or the trial chamber. As Mr. Bemba has not demonstrated a violation of his rights, the question of whether a stay of the proceedings would have been an appropriate remedy in the present case, and the related question of whether Mr. Bemba sought such a remedy before the trial chamber, do not arise. Turning to Mr. Bemba's contention regarding the prosecutor's statements and submissions in relation to his acquittal in the main case, which allegedly impacted adversely on the appearance of the trial chamber's impartiality, the Appeals Chamber notes that Mr. Bemba alleges that the prosecutor's statement and submissions had an impact upon the trial chamber's finding and sentence. Therefore, the Appeals Chamber will focus on their effect on the resentencing decision. The Appeals Chamber finds no error in the trial chamber's finding that the absence of prior convictions was not a relevant mitigating circumstances for Mr. Bemba, as it reached the same conclusion for each of the other 4 convicted persons. Furthermore, the Appeals Chamber finds that Mr. Bemba has not shown that the trial chamber's finding that he was a beneficiary of the common plan required any adjustment in view of his acquittal in the main case. Assuming it was in fact relied upon in the resentencing decision, the Appeals Chamber notes that the finding in question refers to Mr. Bemba's situation as an accused in the main case. The relevant situation was one at the time when the crimes were committed and/or his contribution was made. At the time, Mr. Bemba was an accused person in the main case. Mr. Bemba fails to explain why his acquittal in the main case should have affected the finding in question. Finally, the Appeals Chamber finds that Mr. Bemba has not shown that the findings of the trial chamber and the sentence imposed were affected by the prosecutor's statement and submissions regarding the acquittal in the main case, nor that they were otherwise reflected of an arbitrary approach. Under his third ground of appeal, Mr. Bemba argues that the trial chamber abused its discretion by imposing a disproportionate sentence and fine, and failed to consider relevant considerations and erred in law by imposing a sentence which exceeds the level of his culpability. The Appeals Chamber rejects Mr. Bemba's arguments for the following reasons. The Appeals Chamber considers that by imposing a joint custodial sentence of 1 year imprisonment, the trial chamber explicitly held that when weighing and balancing all relevant factors and revising its previous assessments, it was mindful of the time already spent in detention. In addition, when assessing the proportionality of the sentence, the trial chamber placed special emphasis on the fact that Mr. Bemba, along with Mr. Kilolo and Mr. Magenda, had been imprisoned for significant periods of time in the present case, and that the case had significant effects on their professional reputations, financial circumstances, and family circumstances. Therefore, contrary to Mr. Bemba's contention, the trial chamber took the length of his detention into account. With respect to the fine, the Appeals Chamber finds no error in the trial chamber's approach. The trial chamber's determination of the fine was not confined to the solvency status of Mr. Bemba. The trial chamber's main consideration in determining an appropriate fine was Mr. Bemba's culpability. In particular, when addressing Mr. Bemba's culpable conduct, the trial chamber referred to its findings made in the sentencing decision on Mr. Bemba's degree of participation in the offences. Moreover, solvency is a relevant consideration in numerous jurisdictions, and its underlying rationale is the need to ensure a deterrent effect. As far as individual deterrence is concerned, it was reasonable for the trial chamber to impose a higher fine on Mr. Bemba than on Mr. Kilolo to achieve the aim of individual deterrence. The sentences imposed on the persons convicted in this case were fact-specific and based upon their individual circumstances. It is therefore inapposite to compare the sentences imposed on different convicted persons. Regarding the statutory protection against ne bis in idem, The Appeals Chamber notes that the ruling of the Constitutional Court of the Democratic Republic of the Congo, as summarised by Mr. Bemba, does not amount to a criminal proceeding for corruption or for an offence against the administration of justice in the Democratic Republic of the Congo. The scope of that decision is limited to the eligibility assessment of presidential candidates, and the decision does not contain any determinations as to Mr. Bemba's guilt. Therefore, the issue of ne bis in idem does not arise in the present situation, and consequently the trial chamber did not err. In conclusion, the Appeals Chamber rejects all three grounds of appeal advanced by Mr. Bemba and reconfirms the resentencing decision. That concludes my summary of the judgment. I thank all participants, the interpreters and court reporters, and this session is now closed.
All rise.